Okay, we're going to get started. How is everyone this evening? Great. I am Anthony Crowell, the Dean and President here at New York Law School, and it gives me great pleasure to welcome you as we continue to celebrate our 125th anniversary year. And I'm honored today to celebrate the appointment of Professor Stephen Ellmann as the Martin Professor of Law and to hear his lecture, The Practice and Rule of Law. During the celebration of New York Law School's 125 years and the incredible accomplishments of our community over that time, it is wonderful to have a chance tonight to recognize the achievements and the remarkable scholarship of one of our most prominent and indispensable members of our faculty. And it gives us a chance to hear again the honor and memory of Lester Martin, another person who has had such an impact on our law school and on New York City. So, first, a few words about the magnificent life and legacy of Lester Martin. Lester Martin had a deep connection to this city. He was one of the most successful industrialists in the city and operated some of the country's largest textile mills. He truly cared about people, and this was always reflected in his generous and committed philanthropic endeavors. He had his own foundation and supported a number of Jewish community organizations, homeless services organizations, and he was a trustee of the Grand Street Boys Foundation. The Grand Street Boys Foundation grew out of the Grand Street Boys Association. The association was established for men who grew up on the Lower East Side, and it became a highly prominent political organization. It counted many politically prominent figures in its membership, including Mayor Jimmy Walker and Senator Robert Wagner, both of whom were graduates of New York Law School. Lester Martin himself was deeply engaged in democratic politics in the city, being one of the top fundraisers for many elected officials, and he was a delegate to the Democratic National Convention in 1952 and 1956. The Grand Street Boys Association expanded its scope to serve and help New Yorkers of all backgrounds through a variety of charitable endeavors. Its commitment to helping people and the expansion of its charitable work were largely due to the efforts of its third president, one of Mr. Martin's closest friends, Jonah Goldstein. The association began to give scholarships to students from underprivileged families who were attending local colleges, medical schools, and nursing programs. Eventually, its dedication to furthering educational opportunity grew so much that the Grand Street Boys Association formed the Grand Street Boys Foundation to continue and expand the educational support activities. Thanks to the boundless generosity and efforts of Mr. Martin, the foundation established an endowed scholarship fund here at New York Law School in 1979 that supports students to this very day. He led a life that represented the best of New York, and it is only fitting that this professorship is at New York's law school. The Martin Professorship is therefore the expression of a wonderful legacy and has been awarded to many deserving scholars, including former Dean and Professor Emeritus Jim Simon, who's here with us this evening, as well as former Associate Dean and Professor Emeritus Jethro Lieberman, who is also here and will be speaking in just a few minutes. So today, as New York Law School looks forward to its next 125 years, there is no one more fitting to carry on Lester Martin's powerful legacy through this professorship than Steve Ellmann. Steve is critical to so much of our past, our present, and our future. He has served at New York Law School for more than 23 years, and he is a true Renaissance man with an incredibly wide range of intellectual pursuits alongside his critical teaching and administrative roles here at the school, all making him one of the most vitally important members of our institution. That's why an email about Steve that I received from one of our very distinguished colleagues not surprisingly declared that, quote, Steve Ellmann is among the best of the best at New York Law School, unquote. Besides being the Martin Professor of Law, he is the director of our Clinical and Experiential Learning Program, chair of the Clinical Theory Workshop, co-chair of the South Africa Reading Group, and he is the co-editor of the Clinical Law Teaching and Practice e-journal. As director of our Office of Clinical and Experiential Learning, Steve is deeply engaged as an advocate and intrepid leader for one of the most important parts of our academic program. To that end, Steve played a critical role recently in our efforts to secure a $5 million gift to propel the program forward through the development of a Center for Clinical and Experiential Learning, which is home to all of our experiential learning programs and is known as the Joe Plumeri Center for Social Justice and Economic Opportunity. The new center brings together over 20 law school clinics and all of our other experiential learning programs in one purpose-built and designed space. It puts NYLS at the forefront of the effort to ensure that law students develop a practical, ground-level understanding of the law and the various ways lawyers can use their skills and knowledge to protect those most in need of access to justice and to advance society in general. Indeed, looking back on Steve's impressive career and his scholarly interests, it's easy to see why he continually makes such a profound impact. He received both his bachelor's and JD degrees from Harvard, and after graduating from law school, he served as law clerk to the Honorable Elbert Tuttle, judge of the U.S. Circuit Court of Appeals for the Fifth Circuit. After his clerkship, he joined the Southern Poverty Law Center in Montgomery, Alabama, litigating a wide range of civil rights cases, including institutional reform litigation for mentally disabled people and prison inmates, voting rights cases, anti-Ku Klux Klan suits, and defense work in capital murder trials. He also began his career in academia during this time, teaching courses on constitutional law and federal courts. He taught at Columbia Law School as an associate professor of law from 1983 to 1992, and during this time, he started the clinical theory workshop and continued it at New York Law School when he joined the faculty here. This series continues to bring law professors from around the nation to present papers and lead discussions on various aspects of clinical education. Steve has written extensively on the skills and ethics of lawyers interviewing and counseling of clients, most recently as a co-author of Lawyers and Clients, Critical Issues in Interviewing and Counseling. He has also earned the Sanford D. Levy Memorial Award from the New York State Bar Committee on Professional Ethics for his 1990 article titled Lawyering for Justice in a Flawed Democracy. As many of you know, Steve is also one of the foremost legal experts on South African constitutionalism, not just in the United States, but also globally. He has written extensively on law and rights in South Africa, both under the apartheid regime and in the democratic nation that followed its fall. And as I mentioned, he co-chairs the South Africa Reading Group with Penny Andrews, former dean of Albany Law School and the incoming dean of the University of Cape Town Faculty of Law. He also serves as the faculty director of the South Africa and Rule of Law Project, an initiative of the Impact Center for Public Interest Law that focuses on the achievements of constitutional law in South Africa and the challenges that South Africa faces in building a rule of constitutional law that will endure into the future. As further recognition of his tremendous work on the subject, in 2013 he received a Fulbright Senior Specialist Award to work on comparative constitutional law and clinical legal education planning at the University of Cape Town during that summer. And last year, right in this very space, he organized an extraordinary international conference on 20 years of South African constitutionalism, bringing together renowned scholars from South Africa, the United States, and other nations, as well as a global audience, and which included a keynote speech by the U.S. Ambassador to South Africa, Patrick Gaspard. And since the 9/11 attacks, Steve has also focused much of his scholarship on issues of war and emergency power. He's written on racial profiling as a response to terrorism, war powers in the United States and South Africa, including examination of the military commission system in Guantanamo Bay. Institutionally, Steve has been critical to many of our programs here, serving as Associate Dean of Faculty Development for 11 years, and now, of course, as the Director of the Office of Clinical and Experiential Learning. Our clinical and experiential learning programs have become one of the crown jewels of our community, and Steve was instrumental as we doubled the number of our clinical programs in recent years. We forged many unique partnerships in the last few years, including with the Manhattan DA's office, and just this semester we partnered with Legal Services NYC to offer our first ever Veterans Justice Clinic. The clinic is based on a model that Steve developed in conjunction with our work with Governor Cuomo's office to provide a framework to scale veterans legal services offerings at law schools throughout the state. As a result of Steve's tireless efforts and his ability to work so collaboratively with internal and external colleagues, our clinical and experiential learning programs continue to receive local and national accolades. And I'm proud to say that we were recognized this year as having the top program in New York State. And certainly with the new Plumeria Center space now open, we are well on our way to becoming the top school nationally for clinical and experiential learning. Since I became dean in 2012, Steve has been a key partner with me, and none of our progress would have been able to happen without him. He's one of our most visible scholars and one of our most visionary faculty leaders, and I am grateful for all he does and all that he will do to continue to further build our great institution. And with that, I'd like to invite my colleague, Professor Emeritus and Martin Professor of Law, Jethro Lieberman, up to the podium.
I intend to be brief, but it's hard to be brief about Steve Ellmann. Steve, as we all know and as we've just heard, and as most of us in this room have experienced for many years, has indeed been a significant part of this institution. And of all of the various and many facets of New York Law School life, as administrator, in the classroom, and in skills teaching, and in scholarship. And the dean has just given you chapter and verse of much of that. But in Steve's hands, these are not merely three sets of duties. They have been and are indeed an integrated set of activities. Passionately lived, each infusing and reinforcing the other into a whole aimed at benefiting our students, our colleagues, and the world at large. And that Steve has managed to blend these disparate strands of academic life is no mere happenstance. It has happened because Steve is a learned man, he is an engaged man, he is an intellectual, and a very nice guy. He is learned, as his many books and articles and his range of courses attest, as you've just heard. He is engaged, as his longtime advocacy and searching reflections on clinical legal education show, and not merely coincidentally, as he has demonstrated by his establishing, of course, and directing the clinical theory workshop for all these years, gathering scholars and practitioners from across the nation to think through and push for real reform, and as he has done likewise for legal reform in South Africa. Steve is a true intellectual, not in a pedantic way, but as one motivated by a lively curiosity. Here, for example, are some topics from his personal blog, and these are just in the last few weeks. Whether Dorothy Sayers, many of you may read Dorothy Sayers, the great creator of Lord Peter Wimsey, is in fact an anti-Semite. Evolutionary departures from pure rationality, that is, whether human reasoning suffers from faulty tools. The relationship between good scholarship and good teaching. Plagiarism by Supreme Court justices. No wonder our students have problems. And the normality of a self-contradictory constitution. Steve can enlighten you on those things, and already has in the blog. I, of course, need not do that. And best for last, Steve is a genuinely nice guy. I've been in hundreds of meetings with Steve, I dare say. In fact, maybe 1,000 over the past 20 years. And those are real numbers. And I can report that in every one of these meetings, Steve's respectful attention has always been directed to these concerns. How can we make things better for our students? How can we make things better for our colleagues? How can we make things better for the school? Sometimes, just for fun, I've tried to bait Steve into saying something negative about somebody or something, and I always fail. Never a harsh word. Steve is our friend. So it's Steve's turn, but before I relinquish the microphone, I should say that as high an honor as becoming the Martin Professor is, there's one drawback. Inside these walls, everyone, of course, pays homage. But outside, it turns out, no one knows, as Steve is about to find out, that he is the Martin Professor. I've pondered this cruelty and think I have found a solution. So I invite Steve and Jim Simon to come up to the podium so I can demonstrate how to provide proper reverence for Steve's new exalted status.
I have a bad feeling about this.
No, nothing to be worried about. No, that's yours.
Oh, I'm sorry.
Jim's is slightly different,
Right.
as is mine.
Thank you, Jeff.
She got it.
Okay.
And now at last, ladies and gentlemen, the Martin Professor of Law, Steve Ellmann.
Well, thank you for those wonderful introductions. Of course, it makes me wish that my old mom and dad were here to hear it all. But thank you also to all of you. This chair does mean a lot to me. Your presence, even more. Thanks especially to Dean Crowell, who has supported the development of clinical and experiential education here so steadfastly and also been really nice to me. And thanks also to Jethro for that really gracious introduction. I would be proud to hold any chair at New York Law School, and I'm very glad to hold one that honors Lester Martin, who was so deeply involved in the life of the city. But I'm particularly honored to succeed two such scholars as Jethro and Jim Simon. And thanks above all to my family who are here, my sister Maud, my son Dave, my mother-in-law Frances, and especially Teresa, who makes it possible for me to do all this. I want to actually spend a few more minutes thanking New York Law School. I haven't been here for all of the places, 125 years, but I have been here, as Anthony said, for a considerable time, for 23 years now. And I want to thank the school for its students who are so thirsty for understanding and knowledge, for its faculty, clinicians, and classroom teachers absolutely alike, who welcomed me to their community and are my friends, and whose commitment to learning and teaching is evident every day. And I also want to thank the administration and the staff who go the extra step or the mile to make the school function successfully. That includes, of course, Nancy Guida, if she's still here. She worked so hard on this evening and unfortunately is leaving us. Thank you, Nancy. And it also includes people who respond to emails sent very late at night or over the weekend. And yes, that does mean you, Susan D'Ambra, and also Oral Hope if he's around somewhere. Finally, I want to, like all of you, I want to say a word of just fond memory for Mary Rose Merciesa, who passed away so suddenly last week. There are many more people I could thank, so I have to ask you to let these brief thank yous stand as a proxy for my gratitude to all of you. And now let's do some work. The issues I'll discuss this evening are matters many of us have thought and worried about from a variety of angles, and that's fine. That's okay. My goal with T.S. Eliot is that we shall not cease from exploration, and the end of all our exploring, which will be many lectures and articles and years from now, will be to arrive where we started and know the place for the first time. So my thesis this evening can be stated straightforwardly, though naturally I hope to make it complicated soon. I mean to argue that the reason why law schools should teach students how to practice law is not primarily to add to their list of skills, but to help prepare them for the crucial social role they play, namely the preservation and development of the rule of law. Now, the rule of law is an elusive and critical idea. I want to say a little bit about its components, enough, I hope, to identify some crucial elements, but hardly enough to complete the task of understanding this complex institution. So let me first define it, and simply, as a system of reasonably predictable laws enforced through reasonably just processes as part of a system that protects human rights. Now that last part, the proviso that it's part of a system that protects human rights, could be disputed. It is certainly possible to imagine systems that rule with law but without rights. One of those systems was South Africa, which worked that experiment diligently through a century. The net result of that century, I think, is to teach us that there is no rule of law in a meaningful sense that isn't also rights protective. What you get if you're not protecting rights isn't the rule of law, but rule, as South African anti-apartheid scholars used to say, rule by law. So I want to talk about the rule of law and about lawyers' role in it. I don't want to claim, of course, that lawyers are the only ones who play a role in the rule of law. That's not true by any means, but they are important in some ways that may seem mundane and others that are more dramatic. Let me begin a bit indirectly on what lawyers do with the role of uncertainty in the law. This is easy terrain for law professors. In school, we tend to teach, at least in many of our classes, the tools for developing and manipulating uncertainty. This statutory text, I'm teaching legislation and regulation. This statutory text might be read according to a canon of interpretation that says that if Congress left something out, then it intended to leave it out, and it's just not there. Or it might be read, because it's found to be somewhat ambiguous, it might be read in light of another principle of interpretation which says that purpose can guide the interpretation of the particular words of the text, so much so that it might include the very specific matter left out by Congress. And I guess I want to say, and so on. It's very hard to write language that can't be pushed and pulled by interpretation into meanings that might surprise that language's authors. And doing that work, that pushing and pulling, as well as the writing, must be part of the rule of law for reasons I'm going to try to explain. But meanwhile, before we get into the wonders of uncertainty, actually, a great deal of what lawyers and law users do has very little to do with all of that sophisticated venture into the world of doubt. Much of our legal world is routinized. Driving this fast will get you this kind of a fine. Taking this deduction is reasonable, while taking that one will look bad on an audit. Delivering these warranties will satisfy the other side at the closing on your house. All those are individual matters, but I think the same must be true for a vast amount of the world of business and commercial affairs as well. And even politics. As you may have seen, I think a week ago, maybe just a few days ago, the Mississippi legislature actually resolved a tied election by the application of the statutory method, drawing straws, and did so with enough conviction to deliver the seat to a Democrat, the lucky straw-drawing Democrat, even though that denied the Republican Party a supermajority in that House of the Mississippi legislature. That's the rule of law. That's the regularity of legal processes embodied. And there are, I think it's fair to say, large areas of reasonably predictable, reasonably stable rules by which people do structure their lives, and lawyers' role in guiding their clients' action in light of these rules is an integral part of the rule of law. In that sense, and I think it's a very important one, every honest lawyer's work with her clients on any matter is part of sustaining the rule of law. It's also, of course, part of enabling clients to exercise their freedom within the law, and it's morally valuable for that reason as well. The short of it is that the day-to-day business of law practice is moral work in somewhat the same way that the day-to-day practice of medicine is moral work. Okay. Now, all that sounds like we're all going to get together and be happy. That's not the full picture by a long shot of the rule of law. A world governed by the rule of law is not at all a world free of conflict, and another role of lawyers is to help resolve such conflicts. My colleague Becky Roife has explored the 20th century professional ideal of legal professionalism, in which the lawyer is a coordinator of society. In somewhat the same vein, lawyers are sometimes said to be excellent problem solvers because they are experts in the processes by which problems can be solved. And so also Anthony Croneman has written in his 1993 book, The Lost Lawyer, about the lawyer-statesman, a lawyer of an earlier age than ours who was distinguished by, and now I'm quoting, a broad familiarity with diverse and irreconcilable human goods, coupled with an indefatigable willingness to enter the fray, hear the arguments, render judgment, and articulate the reasons that support it, even when all hope of moral certainty is gone. At war with itself, says Croneman, this complex set of attitudes nonetheless describes a recognizable moral ideal, an ideal closest perhaps to the public-spirited stoicism implied in the Roman term gravitas. Now, I don't at all want to minimize the importance of this form of professionalism or statesmanship, but I think we must recognize that it's in a deep sense conservative. It maintains, it regulates. It doesn't provide the impetus for change, at least not so much as it handles change surging from elsewhere. Justice Harlan, about whom Nadine Strassen spoke so eloquently in the last of these investiture speeches, is perhaps an exemplar of this wise conservatism. It's to be admired, but it isn't the whole of lawyers' role in change. The impetus for change comes elsewhere and remains to be accounted for. I've learned about the importance of change in the rule of law from several sources. Ed Purcell's book on Brandeis and the Progressive Constitution taught me, I hope I got it right, that the rule of law rests on no absolute foundations at all. There are vast areas of relative stability, but nothing lasts forever, neither the texts nor the meanings of texts, and in fact, lawyers and judges' reasoning and advocacy skills are always being deployed in efforts to change the rules in one way or another. Often, moreover, again, taking my text from Ed, these efforts are not purely motivated and not transparently conducted. And all of that is part of the actual nature of the rule of law. Similarly, Frank Munger, in his ongoing work on Thailand's cause lawyers, seems to me to be demonstrating that the path to the rule of law doth not run straight, both because the moves that may make a positive difference in any society depend on the nature of that society, and I think because the ultimate outcome, that society's rule of law, may turn out to be quite different from ours. So change is important. And struggle, indeed, it seems to me, is integral to the rule of law. And by no means all of it is modulated by the august lawyer-statesman of Croneman's vision. For me, that lesson came through most clearly in South Africa, which, as many of you know, has been an important part of my academic work and my life since the mid-1980s. The critical lesson South Africa teaches on this score is that many of the greatest lawyer-statesmen, in South Africa, we all know Nelson Mandela, but Arthur Chaskalson, my friend and the first head of South Africa's new post-apartheid constitutional court, stands out as well. They were not dispassionate. They had not lost all hope of moral certainty. They were deft, even masterful in their use of the tools of legal argument available to them, but they were never infatuated by those tools. Instead, they were absolutely convinced of the rightness of their cause, the fight against the inhuman blight of apartheid. Mahatma Gandhi, another lawyer, was surely no less convinced of the rightness of overthrowing British colonialism. And when we stop to think about our own history, I think we see many similar examples. Thomas Jefferson, John Adams, Abraham Lincoln, Franklin Delano Roosevelt, Thurgood Marshall, Ruth Bader Ginsburg. These statesmen and stateswomen were not Stoics, but revolutionaries, either metaphorically or literally. Some of them, like their counterparts in South Africa, violated the law, sometimes extensively, in what I would call the cause of the rule of law. And this, too, is a role that the lawyers we are educating may come to take up. So I hope I've sketched some of what lawyers do in a way that makes it possible now to talk about what the education that we are providing them how it helps them to do those things. So I want to begin, in a sense, paradoxically, with the impact of clinical and experiential education on legal reasoning. I say paradoxically, not because I think it truly is a paradox, but because legal reasoning is often thought to be the exclusive domain and subject of classroom courses. I'll talk about that. Then I want to ask, and here perhaps I'm going to be more controversial, at least with my clinical colleagues, than in the rest of what I say. I want to ask which clinics can best have this impact and for which students. And then I want to look, finally, at two overarching contributions to the rule of law that legal education in the practice of law has provided. The liberatory, as I see it, the liberatory effect of the idea of client-centeredness and the profound clarification that this form of education offers into the moral nature and moral ambiguity of lawyers' contribution to the making of the rule of law. So let me start with legal reasoning. Acknowledged rightly by all as absolutely integral to the lawyer's work. I don't at all suggest that clinical and experiential education is a substitute for classroom training in legal reasoning, but actually classroom training is often not a substitute for clinical and experiential education in legal reasoning either. After all, the theory of expertise, which I had occasion to try to study in understanding what lawyers might actually do as they become experts. The theory of expertise indicates that expertise is not, there is no such thing as just an expert in everything, not remotely. Expertise is expertise in a domain. Transferable expertise is limited if it exists at all. An expert musician is not an expert conductor. An expert in moral philosophy is not an expert in literature. And an expert in legal reasoning from books is not an expert in legal reasoning that must begin from an encounter with a client and with the client's ambiguously expressed facts and ambivalent desires and must work from there towards a legal approach that will achieve the client's objectives. If we trained our students, I don't believe we do this at New York Law School, but if we trained our students only to be expert reasoners from books, we would have trained them in the wrong thing. Okay. But to speak of legal reasoning by itself implies that this skill is something disembodied, distinct from the rest of the humanity of the individuals who employ it. And that can't be right either. If emotion shapes cognition, as much current research tells us, then emotion surely shapes learning as well. And now I'm reciting familiar chapter and verse in clinical legal education. Few things give students so much reason to learn as the awareness that a client's well-being turns on what the student acting as a lawyer does, and few things give students so much of a sense of accomplishment as having in fact successfully protected a client's interest. If we cannot give students these powerful experiences, we risk dampening their curiosity and limiting their engagement. We risk undercutting their learning, not just of the values of client representation, but, again, of the elements and skills of legal reasoning. Okay. Now, all that's quite general. Let me now be a bit more concrete about which clinics can do this for which students. Data collected in two NALP surveys. Let me just pause to say that NALP used to stand for the National Association of Law Placement, but I believe it is now one of those acronyms that is just itself. Two NALP surveys, soon to be discussed in a forthcoming clinical law review article by Meg Reuter and Joanne Ingham, make clear that students who choose public interest law find a home during law school in skills courses, and especially in those where they work on actual legal matters, clinics, and externships. Many of these students, I'm sure, are also thrilled by the chance to work with like-minded faculty. Their clinic and externship experiences give them the chance to live and develop their ideals, and their experiences also help them to enter the job market with credentials and references that may make a crucial difference. I think we do a very good job launching these students into the world, and these are, I suspect, the students likeliest to play the rule of law role of demanding that the system change. But what about the students and it's actually probably most of them, who graduate and enter private practice. The NALP data admittedly focused in this respect on students who entered big firm private practice, and so not necessarily applicable to students who go into other forms of private law. Those data, with their limitations, say that these future private practitioners took fewer clinical and experiential courses while they were in law school. And although those who took the courses liked them, they liked them less than their future public interest counterparts did. Now, what accounts for that? It seems to me that one likely answer is that the future private practitioners doubted that taking courses focused on public interest or public service, as most clinics and externships probably are, they doubted that those public-minded courses would really help them prepare for the careers they envisioned, and that surely reduced their motivation. Moreover, I think they were right. That is, again, expertise theory says that we become expert in domains. While the exact dimensions of a domain can be debated, as Ian Weinstein has reminded me, criminal defense is a long ways from patent law. It is easier to take what we learn in one area and apply it to another that is very similar than it is to transfer it to some field dramatically removed from the one in which we've been trained. And so I think it follows that we clearly need clinical and experiential training that is set in or at least near the fields of private practice into which our students are likely to move. In fact, at NYLS, we already have several such clinics and are discussing more. Needless to say, Deborah, I also think our traditional social justice-minded clinical and experiential offerings are essential. Happily, at NYLS, especially with the benefit of the wonderful gift from Joseph Plumeri that's given us the Plumeri Center for Social Justice and Economic Opportunity. Thank you, Dean Crowell. We have the opportunity to build on multiple fronts. But what I most want to say is that if I'm right, that the roles our students will play in the private practice of law will be part of the maintenance of the rule of law, a rule of law that aims for justice and honors human rights, then creating such clinics is not a departure from a social justice mission. Instead, it's another way to contribute to social justice. And it's actually a very special opportunity to infuse into the teaching of the practice of law in these fields of private law a sense of those fields' social significance, so that we don't wind up essentially telling our graduates that their work is only socially meaningful on the days when it happens to fall in the cabin of what we call public interest law. Now I want to speak a little more broadly about two particular contributions, it seems to me, clinical and experiential education has made to the shape of the rule of law, to our understanding of the rule of law. The first is the idea of client-centeredness, probably the single most important element of the past 40 years academic, which is to say, in this respect, clinical reconceptualization of law practice. Clinicians study law practice as doctrinal teachers study law doctrine, and the impact of that somewhat removed reflection, that academic reflection, is important. Now, the idea of client-centeredness can be seen in more than one way. Again, Becky Roiphe has thoughtfully argued that it can be seen as a form of lawyers drawing back from their professional role of managing social conflict. And that point has force, especially if client-centeredness becomes a form of self-enforced passivity on the part of the lawyer in his or her interactions with the client. But I don't see it that way. I think client-centeredness is, or should be, in a phrase that Bob Dinerstein coined, engaged client-centeredness, in which the lawyer offers the client the full benefit of the lawyer's experience while trying hard, it's no simple matter, to simultaneously assist the client to make his or her own choices. In calling on lawyers, law students who will become lawyers, to practice this way, and it seems to me that clinicians have been actually adding to the foundation of the rule of law by removing an often overlooked form of lawless or arbitrary power, the lawyer's imposition of his or her will on the client, by removing that from the processes of the law itself. And I want to say the work is not yet done. The lawyer-client relationship is a complicated one and unequal, sometimes in many ways, and the task of developing an understanding of what the lawyer committed to the rule of law should offer her client is a task that's not yet complete. Now, the last contribution to educating our students for the rule of law that I'll discuss is surely the most paradoxical. This part's not paradoxical. We teach our clients, our students, about moral values. And often we do so by supporting the students' most idealistic impulses, which contribute so much to achieving zealous and caring representation. But we also do so in good part by teaching them about moral ambiguity. Lawyers, to come back to statutory texts again, lawyers are faithful to legal texts, except that what those texts mean is always subject to argument and re-argument, and almost nobody seems to think really that the answer to the question of what does a text mean is, what was it intended to mean? Or to give a different and important example from Richard Sherwin. Richard has been exploring in depth the ways that today's media, such as film and video, affect how legal decisions are made. Well, once we know that these effects exist, we know, as Richard has said, that lawyers will, indeed as zealous advocates, they must make use of them. They must manipulate them. As Richard, I think, would say, may have explicitly argued, in principle, this is no different than what advocates since Demosthenes have done with the techniques of rhetoric. And this can be generalized. As we learn about human beings' cognitive limitations, we also, in the same breath or the same sentence, are learning about techniques that might manipulate those cognitive limitations. So in recent years, for example, there's been a lot of attention to the power of narrative as a way to convey to a decision maker the human essence of a situation. But we know that human beings' reasoning is limited by what's called the heuristic of availability, which essentially says that people tend to decide things based on the examples of such things that come most readily to mind. We exaggerate the risk of shark bites because the stories stick in our minds, and narrative helps make things stick in our minds. So of course we should use narrative, but we ought to be clear about the extent to which we are engaged, not in presenting absolute truth, but in conveying within the rules, to be sure, a story of what the truth might be. And as students learn these skills of lawful but manipulative advocacy, they also encounter, often and perhaps inevitably, the reality that their clients, on whose behalf they engage in such careful work and for whose well-being they care so much, may be lying to them. And that brings us back emphatically to the rule of law. Ed Purcell wonderfully examined in the book I mentioned the maneuvers of judges in particular as they seek to shape and reshape the legal system. But maneuver and manipulation is part of the rule of law at every stage. I don't mean to suggest that it's lawless or unprincipled. Quite the opposite. It's law-governed and should be principled. And this behavior is an integral part of our creation of the rule of law. From the crooked timber of humanity, as Ira Berlin said, nothing completely straight can be made. But from the lawyer's role in seeking for flawed people and by means that may exploit other people's limitations, what the law provides, from that role can and does come a rule of law. We can arrive at this place, and because we and our students know it for the first time, make of it the best place that it can be. Now I get to put my hat on. Well, I don't want to delay the reception, but yes, I'm happy to talk about all this. Yes, Robert.
Congratulations.
Thank you.
So
Well, I start with the proposition that the lawyer, even with that client, should ultimately do what the client directs. The main question that then presents to me is, should the lawyer try to push the client, push I'm going to use as a generic term, in some way to stop directing the lawyer in this bad way? That's a controversial question, and one that, where's Bob Dinnerstein? One that Bob Dinnerstein and I and our co-authors probably never quite agreed on in the book we wrote that includes a chapter on that subject. But the chapter I wrote, and the position I took is that it is legitimate for lawyers to press a moral case with their clients, even though, once again, I think ultimately that pressure needs to be circumscribed so as not to deny the client the right to choose. As a practical matter, I think that kind of moral suasion is probably most effective not in the case you described, the virtual alien who enters as in Rick, the man from Mars, who enters your office. I think it's probably more effective with the person with whom you share a substantial measure of common ground from which you can reach out. Everybody else is persuaded? Guess not. So I think we should go eat and drink a bit.